Welcome back. Today we are examining a neighborly dispute in Tennessee that rapidly devolved into an unlawful arrest. So, welcome to America, where all you have to do to ruin someone's life is just call the cops on them and make some crap up. This guy made a bunch of stuff up about his neighbor, and they assumed it was all true, and just went over there and didn't look at the scene and investigate. They just took what the first witness said as true, which is often the case. Um, so let's cut straight to the facts. There's two neighbors, Kelly and Trevor, and they have a long-standing property feud. Kelly calls the sheriff's office claiming Trevor fired a weapon in the air to intimidate him. The deputies arrive and locate Trevor on his lawnmower, and he walks up with a pistol on his hip, and they're like, "We're taking the gun off your hip." He's like, "No, you're not. You're not taking it," and they take it anyways. So it starts off, it's pretty, and they're in the backwoods in Tennessee, in the middle of nowhere. So this would be really scary if you're a cop walking into this situation. I have nothing against the police here. I personally think they did a decent job, but they still violated some of his rights. So we're interested to see what those are. Let's address the first legal hurdle. Did the deputies have reasonable suspicion to detain Trevor? Is the question. And yes, they received a corroborated report of a firearm being discharged during an active dispute, and they did see the firearm and take it. Under the law, a brief investigatory detention is permissible here. Furthermore, taking temporary custody of his sidearm for officer safety is a standard procedure that courts routinely uphold. At this exact moment, the detention is lawful. But here is where the deputies completely abandon their duty to investigate. Trevor explains that he fired 2 rounds into the ground to clear chickens out from under his vehicle. So this dude if the chickens are all congregate together around his car, so he fires shots into the ground to get them away. And apparently he does it a lot. Um, Instead of walking a few feet to verify if there are fresh bullet impacts in the dirt, which is basic police work, the officers become entirely fixated on forcing him to provide his ID. Let me be absolutely clear about the law here. Tennessee is not a stop and identify state. There is no legal statute that criminalizes the refusal to provide identification to law enforcement during a simple investigatory stop. The officers threaten and then execute an arrest for failure to identify. This is a secondary charge. You cannot be charged with a secondary offense without a primary crime. It is a legal impossibility. It would be like having a Charizard with having never been a Charmeleon or a Charmander. It's not possible. You must start with the first evolution before you evolve to a second one. What you are watching on this body cam footage is police officers substituting actual evidence gathering with an unlawful demand. When an officer tells a citizen, "We don't know if you committed a crime, so you have to identify yourself," they are openly admitting that they lack probable cause. A lack of knowledge does not grant the state a blank check to make an arrest. Because the deputies realized their initial arrest rationale was legally baseless, they later slapped him with reckless endangerment and obstruction charges. Those charges were ultimately dismissed, but the damage was done. Trevor was forced to post a $2,500 bond, lost his firearm for months, and his family was severely inconvenienced. As for the neighbor Kelly, he operated on an assumption. He assumed, and you know what happens when we assume? We make an ass of you and me. Trevor fired into the air. He assumed that Trevor fired in the air. Citizens have the right to contact law enforcement when they feel unsafe. However, police officers do not have the right to treat a neighbor's fearful assumption as absolute fact without conducting an investigation. Every ranking officer on that scene, right up to the highest local authority, enforced a law that does not exist. This is not a harmless oversight, it is a profound and systematic failure in fundamental constitutional training. When the individuals entrusted with the power to detain and disarm citizens do not understand the absolute limits of their own legal authority. They become a liability to the public. Know your rights, because this video proves that people policing you often don't. All right, let's start the video.
Welcome to America, ladies and gentlemen, where all you have to do to ruin someone.
What you're going to do, then I'm saying it's not okay as far. Okay.
Yeah.
Yeah. I do. But there's directly in line with this. And he come out there and stood behind that van right yonder. And I assume he shot up in the air. But you can see his little target sitting right down there is directly in line with us. He shoots every friggin' day we come out here.
Okay.
If we're outside, he's out here shooting. And it's a constant agitation with him.
He doesn't like him shooting guns.
But, you know.
All right, let's see if we can get this full screen here for you. And
He wants to shoot guns while
let's go. Full screen.
Along with living there. This is Kelly. Kelly also enjoys the freedom that comes with living out in the country, and he owns a few acres of occasional. Deputies arrive.
A dispute about the property line, and
all right, here we go. This is the first one.
I've asked him to stay off me, so I'll come out here and was just going to put up a fence. I've not said anything to him, and he come out there and stood behind that van right yonder. And I assume he shot up in the air, but you can see his little target sitting right down there is directly in line with us. He shoots every friggin' day we come out here.
Okay.
If we're outside, he's out here shooting, and it's a constant agitation with him.
I got you.
But, you know, he wants to shoot guns while we're sitting over on the porch. It's pretty stupid.
Yeah.
But with no backstop. But we're down here fencing, and he's out there popping off rounds. I'm going as far. This has been going for 5 years.
I got you.
We ain't spoken 2 or 3, so.
Okay.
But it never ends with him.
I got you. You got your ID with you, sir?
I do.
After speaking with Kelly and getting his side of the story, the officers located Trevor on his lawnmower in his yard and made contact with him.
Yeah. Ooh.
It's right over here.
Oh, it's right this way. It's closer to the property line. How are you? Good.
I'm doing all right.
I think another one coming.
It is.
Yeah.
Okay.
I'm Sergeant Everton. This is Sergeant Meyer. She's going to be one dealing with you. Anytime we deal with a call that has to do with a gun, I'm going to take it off your side, okay?
No.
Yes.
Well, if that's what you're going to do, then I'm saying it's not okay as far as I'm concerned.
Okay, well, we're going to take it off your side.
All right.
Okay.
So
Okay.
The reason that we're here is we got a call about someone firing shots up in the air. Okay. So that's why there's so many of us coming out. Okay.
Pretty interesting. I can't wait to get the y'all's body cam from you.
Yeah.
And you said Everton and Meyer.
Sergeant Meyer.
Well, there's no crimes being committed here. So
Look, we're not saying that you committed a crime.
No,
we're just saying that
statement.
we've got to. I understand that.
Right. Yeah.
And I'm not an advocate to take people's guns. I'm not. But it's just an officer safety thing. As soon as we figure this out, if there's nothing wrong, I'm gonna give you your gun back. I'm cool with everybody having guns. I'm cool with everybody walking around with them. We're definitely pro-gun. I'm not here to take your gun. I'm not here to try to infringe on your
y'all are
rights.
doing a good job so far. I can't wait to see what this Tuck guy's bringing in now.
Okay. So at any point did you fire your weapon up in the air, sir?
No.
Okay. Why would we get a call that said that you have?
Whenever I started my mower a minute ago, all my chickens was congregated underneath my van once again. So I dropped 2 shots in the ground to scare them all back to their coop. Okay. But it wasn't in the air. There was 2 shots fired, and it was in the ground.
Okay.
It clears them out fast. It's not the first time I've done it.
I got you. I understand that completely. So at no point you fired the weapon up in the air?
No.
Okay.
I would never fire a weapon up in the air. I just got finished with a training class this Saturday.
Yeah.
Yeah, what goes up comes back down.
Yeah, you don't ever fire a weapon. I just fired them off into the ground.
All right, you got your ID with you, sir?
I haven't committed any crime.
Sir, we're out here for a call for service. We have to identify everybody.
Now I wish I had a camera. Your camera's on, sir? Okay, I can't tell if it is. Yours is? Okay. And you are Vincent, and you are Woodard?
Mm-hmm. Okay. Yes, sir.
Yeah.
This guy's pretty good. He makes sure that everyone's body cam is on. He asks for all their names. I wonder if is he an auditor and this is where he lives in the back hills of Tennessee? I don't know, but he seems like he's done this before.
No, actually, I don't have an ID on me, but I'm not going to ID. I'm not giving you my name and date of birth because there's been no crime. I protect my Fourth Amendment.
The Fourth Amendment at this point gets put aside when, okay.
I'm not going to fight you. I'm not going to resist, but I'm not going to ID.
Look,
I've done
he's
no
trying to
crime.
arrest himself.
Listen to me.
But I'm just...
He's trying to arrest himself here. He's like, here you go, take me away. I think he knows he can win some money if they arrest him. I don't know. That's odd. But he's making it clear he's not going to resist any arrest.
I'm really glad.
Listen. We don't want to arrest you. Listen,
well, you don't want to ID me either because I ain't committed no crime.
We have a right to ID you because we had a call for service out here.
No, sir.
You said that you fired shots off.
I didn't say that but she asked if I fired him in the air. So it doesn't matter if I fired shots off on
So
my
we
property.
get a gun call. You see what I'm saying?
No.
We get a gun call.
No. Am I arrested? What am I arrested for?
Right now, you're detained.
Okay. Well, if I'm being arrested for not giving my...
Right now, we're trying to give you a chance to tell your side and try to ID you that way that...
I'm not ID.
You're not IDing.
That's what... I'm not refusing to ID, but until you give me a lawful reason as to why I have to ID...
Okay.
Because we got a call for service. And
that call for service is not a lawful reason to ID, sir.
Yes, sir.
It is.
No, it ain't, because anybody could call and make anything up. If I hadn't shot fired those shots and he called it up and lied to y'all...
We still go get his ID, too.
So what if you're
already
lying
got
that you
it.
shot it in the ground instead of you shooting at them?
Oh, was it? But that's burden of proof is on them. It's not burden of proof for me to prove I'm innocent, is it?
That's why we're out
Well,
here.
I'm just making a statement. It's
on.
not... You got cameras on your eyeglasses, too?
No.
No, I just saw the little circles, and I didn't know if it was those...
Those are blenders.
Well, no crime's been committed, so I don't know quite what to say.
Let me explain, like, the reason for IDing.
I'm not really wanting to hear it. I'm really not. Are you going to arrest me for not...
Okay, so he does seem to know the law. He is stating the Terry v. Ohio precedent. Here it is on the screen. Under the Fourth Amendment of the U.S. Constitution, a police officer may stop a suspect and frisk him or him or her without probable cause to arrest if the police officer has a reasonable suspicion that the person has committed, is committing, or is about to commit a crime and has a reasonable belief that the person may be armed and presently dangerous. So here, it's very debatable whether they had an articulable probable cause to arrest. Now, most likely they didn't, because the reason for arrest here, they said, is failure to ID. Not they don't actually have any proof or believe that he shot at the other people enough to arrest him for that. So perhaps if they would have said, well, we think you shot at your neighbor, we're arresting you for that, perhaps it would be different. But that's why it's important to ask the police, like, what is your reason? What is the probable cause? Why are you suspicious of me based on what? Where does your suspicion arise from? What is the root? What is the cause? What is the source? And here the source was a secondary crime. So let's get back to it.
For failure to ID, because that's a secondary charge. You got to have a crime first, and I have not committed any crime.
I've tried to explain to you why we have to ID you, sir.
I'm trying to explain to you why I'm protecting my Fourth Amendment right. And had I known that it was going to be this way, I would have went and got my phone camera so I could have recorded this. Am I free to go?
Not right now, sir.
Okay.
No.
Okay. What crime are you detaining me for?
It's an investigation.
Okay. Should we move off of my property because y'all are currently trespassing and I'm rescinding any...
No, we're not.
Again.
Okay, I'm just
Call for
rescinding
service.
any invite or any type of y'all are on here because of y'all and y'all's lawful orders. Not because of being invited, and not because this is casual.
10-4.
I understand, sir. Look, we don't want to have to take you to jail.
I don't want to go to jail. But if you're going to arrest me on something that is a secondary offense when you actually have no original crime, then that's just something I'm going to have to fight in court. Isn't that what you always say? No roadside court. Just do it after the fact, and if I have to sue
I think this guy is quoting the law better than I am as an attorney. So whoever this guy is, you're the man. He's stating it very clearly and with great knowledge. So kudos to this guy for having studied the First and Fourth Amendments and the Supreme Court cases and knowing exactly what a secondary and a primary crime are, knowing how to articulate it under pressure while maintaining a calm composure, knowing to disinvite the police officers, knowing to ask, am I free to go? Am I being detained? Delineating all of this for the body cams. He's just doing a fantastic job.
county, then I sue the county. No big deal.
Well, we have to see who we're messing with. We have to run their IDs, see who you are, you say you are.
Just because somebody give you a call to service doesn't mean I have to surrender my Fourth Amendment right. It does not.
It's not a Fourth Amendment right.
No,
we've come out here for a reason.
It's right now. This is an investigation. You can investigate if he has proof that I shots fired. Matter of fact, you didn't even say shots fired at him. You said shots fired at him. You said, how in the world do we know, since you said they were shots fired, that you didn't shoot them at him? She didn't even say shot at him. She said shot in the air. Shot at him would come up on your part.
You said that you shot in the ground. How do we know if you shot in the ground or shot up in the air? Because they called in and said you shot up in the air. How do we know if you shooting at
Well,
them?
then they need proof, or else they're filing false out. They're filing. Are you gonna let me answer? Either they are filing false allegations, or your investigation will prove otherwise. But until you have the proof, the burden of proof is not on me to prove that I didn't shoot in the air. Now I'm sitting here telling you I'm not a moron, so I didn't shoot in the air.
Okay. We're not saying you're a moron, but
no, anybody that does is though.
We either need an ID or name and date of birth.
Put your hands behind your back.
Yes, ma'am.
Put your hand together like you're praying, so that way it doesn't pinch you.
And what am I being arrested for?
Right now, failure to identify.
Okay, failure to identify is a secondary offense. You need an original charge. It's on the contract.
Okay, so he asked, what am I being arrested for? And she gives the worst answer possible. Failure to identify, even if this is a stop and ID state, which half of all states are, even so, they still need an original crime. So look at, let's look at this together. So even if they're in a stop and ID state, the initial detention must be a lawful Terry stop. If law enforcement lacks reasonable articulable suspicion that a crime has been, is being, or is about to be committed, the encounter is strictly consensual. In a consensual encounter, the citizen is free to leave and free to refuse to provide ID. That's Brown v. Texas, a case where the police observed Brown walking in a high crime area. They stopped, detained him, and he refused to ID, so they arrested him for refusal to ID. Well, the Supreme Court said they overturned his conviction in Texas and said the court that someone simply for failure to ID, you cannot compel them to ID. It's an unreasonable seizure under the Fourth Amendment. So because the officers lacked reasonable suspicion of any specific criminal conduct, he was just walking down an alley in a high crime area, doesn't mean he's a criminal. He was not seen doing anything criminal. And so they can't just assume that he's a criminal because of where he's walking and the time of night. It's 4 a.m., whatever. So there has to be a reasonable suspicion of a specific criminal conduct. Specific, right? Specific. The application of the Texas statute was unconstitutional. Even the Supreme Court later upheld the general constitutionality of stop and ID statutes in Hibble v. 6th Judicial District Court of Nevada. It did so with a massive caveat: the statute is only valid if the initial stop is justified by reasonable suspicion. So the initial stop has to have reasonable suspicion. Here, you could argue that the call itself saying that he shot his gun at them or in the air, that's reasonable suspicion. He did admit that he did shoot his gun twice, and so that admitting that he shot his gun while they were out there by the fence, I mean, arguably that could be enough. And if I was the police officer, I may have arrested him as well. But they did not see him shoot the gun in the air. They didn't find any bullets. They didn't investigate the holes in the ground to see if he was telling the truth. So there's more they could have investigated, and so there really wasn't enough reasonable, articulable suspicion a crime had been committed here. But it's really, really, just like this property dispute, it's right on the line. All right, guys, let's go.
There's no disorderly conduct on private property. I didn't do anything.
Now look, we talk all the time on this channel about how to accompanied by other factors. Here, the officers didn't just receive a call for service. They also located and spoke with the caller, corroborated who the suspect was, and then located Trevor with a firearm. They took some investigative steps to establish that a crime may have occurred and that Trevor may have been the perpetrator of that crime. And that's the kind of fact pattern that generally supports a brief investigatory detention. Reasonable suspicion is a very low bar for officers to meet. And although we see plenty of officers who fail to meet that very low legal standard, that doesn't mean that it isn't still very easy to satisfy from a court's perspective. In fact, there are Tennessee cases where a gun-related call plus an on-scene witness identification supports a brief detention. So the fact that there was a corroborated report of potential criminal activity with a firearm where the officers positively identified an armed suspect gives them a strong argument that they had reasonable suspicion and were within their authority to temporarily detain Trevor. But that doesn't mean that the officers had the authority to identify him. Tennessee is not a stop and identify state, and it doesn't have a specific law that explicitly criminalizes the act of refusing to give your ID to members of law enforcement while being detained or arrested outside the context of a traffic stop. So the whole idea that these deputies could potentially arrest Trevor for refusing to identify is just complete nonsense. And it says a lot that literally every officer who responded to the scene, including the chief of police who you'll see momentarily, were completely unaware of this. One more thing I want to point out before we jump back into the video is that I hate this stupid logic trap that officers keep using against citizens. Officers love to say, well, we don't know if you committed the crime, as if that lack of knowledge somehow justifies a detention, when in fact it just shows that the officers didn't have enough evidence to make a legitimate determination. Here, the deputy asked Trevor how they're supposed to know which direction he fired his weapon in, and that obviously implies that they don't know, which means that they don't have any evidence of any criminal use of a firearm. I mean, how could they know if a crime was committed if they clearly don't know which direction the firearm was shot in? They're basically just trying to flip the burden of proof in real time to avoid having to carry out an actual investigation. And the fact that the entire police force on the scene is doing this is a testament to the state of the training infrastructure for policing in this country.
Which one was the caller?
Me.
You was?
Yes, sir.
Okay, do you care to tell me what happened?
This has been an ongoing dispute. I come down here and I tied a string and I drove one post. He walked out and stood and watched for about two minutes, maybe, while me and Julio was staying here talking, and he shot 3 rounds in the air. Now, his little target's sitting right there between us and that van, and he's out here about every day when we're home, only when we're home that I know of. He comes out here and shoots guns at, and back this way. I mean, we're just right over there. He don't even know where we're at. I really just need it documented so when it escalates, my wife's been telling me to do this for years, and I don't want to.
Yeah, I mean, I get it.
I'd rather just let it go because I don't want the headache.
Well, the reason I'm asking is because he's he's just being confrontational and saying that we're violating his Fourth Amendment rights and he's not going to ID. And
Come out, he stood and stared for about a minute. Then he shot 3 rounds in the air and he hopped on his lawnmower and rode back here. I'd say he realized he screwed up when he shot in the air.
okay,
I don't know that he did, but this is not over.
yeah.
You know what
You
I
don't
mean?
know. What do you mean you don't know that he did? What do you mean by that?
I mean, in his eyes, he just thought he was,
Oh, you're
that I
saying
wasn't
that
gonna
you
do
don't
anything
know
about
that he.
it. I've let it go for so daggum long. But now to be honest, I don't know that he shot back here. I'd say he shot in the air, but it's
Okay.
still.
All right. Well, let me talk to Chief and then.
Right together.
Yeah,
Little more.
you are being
Little more.
disorderly when you're not
No,
doing what we're asking.
no, that's not
So-
disorderly. Disorderly.
What they should have asked is, how do you know he shot in the air? Did you see him point the gun in the air? Did you see a bullet fly in the air? What leads you to believe it was in the air and not into the ground or into somewhere safe? Now he said there's no backstop to stop the bullet. But if you shoot into the ground, you don't need a backstop, right? Because the bullet's going into the ground. There's the ground is the backstop. So, right, it's right on the line here, though. It could go either way. I could see how you could say, maybe the neighbor also had a reasonable suspicion that the shots were in the air, just based on the sound and the proximity to how close he was to them on the property line. Who knows?
Can you even be the complainant in a disorderly, or do you have to have somebody else?
You absolutely can.
Okay.
All right. Do you have anything else on you, sir?
Yes, I got a magazine
Okay.
in this pocket right here.
All right.
Or I'm not giving you permission to take any of
Well,
my
you're
belongings.
in custody right now.
Okay,
so
I'm just
search
letting you know.
incident
Well-
to arrest.
That's a false arrest.
All right. All prerogative.
No, it's law.
Okay.
You either follow the law or you don't. You're supposed to be here upholding your oath to the Constitution.
You're right.
Well, this is a Fourth Amendment oath violation. You don't have a crime.
Some bullshit call and stuff like that. I said, well, we don't know if he's shooting up in, shooting up in there. That's why we're out here for a call.
He refuses to, or whenever I left, he was refusing to ID himself. He says he's not committed a crime. We're violating his Fourth Amendment. I took his weapon off of his side whenever I got here because it's a safety issue.
You're gonna call for service.
It doesn't matter if you get called for service. Any loony can call you up and tell you to go
All right, sir, come on.
search somebody. Yeah.
Mine's the first car over here.
He's even claimed that he's fired off rounds, but he claims he shot him in the ground. He claims that he fired him off in the air. There's another witness that.
It's okay. I'll find a statement saying.
Have a seat. I got it.
He's really gonna hate his neighbor after this one.
I'll give you the firearm that come off this side. I just put it in my passenger floorboard. That way it was out of play.
All right. Well, you're to identify. I'm pretty sure he's intoxicated. I can smell it on him.
I
so.
can smell it.
Well, I mean,
Well, there you go.
it's disorderly too, isn't it? He said he can't be on private property.
I'm not going to stand out here. It's too hot.
He's intoxicated.
We tried to be nice and give him
He's
the.
admitted to shooting. If you don't cooperate with the investigation, you can only go off what your witness says.
Yeah.
I mean,
Well, I mean, I know what.
not much option. Reckless endangerment. Exactly.
That's my whole thing. Is we've got the reckless endangerment. Kelly
How's it going?
I think I'm better than you are. I don't know exactly what's all going on, but
I just had any things. I had a daggum neighbor dispute. You know, well, I do. This ain't over with.
I'm sure of that.
He said he fired 2 shots into the ground to scare chickens back away from his vehicle. So, had he just identified himself, it could have been a report and we'd be on our way. But
Well, we don't know if that's really what he did.
Yeah. I mean, that's what you're trying to explain.
Yeah, that's what I was trying to explain to him.
How do we know if you?
He said I was calling him a moron. I can smell it on him.
Coming out here shooting air, me standing in my driveway is about all I can stand. So I probably should tolerate more, but I don't know. I think this is the worst thing I probably could have. But I'm tired of it. You know what I mean? I need it on record that
Well, unfortunately, for if we don't start doing something, it's going to get worse. And I'm not saying that it won't.
Yeah,
this time,
exactly.
but at least you've done your part. To try to prevent it going to the next step.
Yeah, I don't believe it will.
Are you just gonna bring it down there for me?
What's up?
It's gun.
I'll give it to you.
All right.
After arresting Trevor and taking him to jail, the deputies eventually tracked.
They were very partial to the first witness. So, whoever is the first witness, they taint the mind of the police. And so then the second witness is oftentimes less believable. And so it pays to be the first witness. But here's a classic case of, being the last bite of the apple, being the second one here that really worked against this guy. And his story was just not believed at all. And they've just believed the first witness without really any corroborating evidence on scene. Just take his word.
Down Julio, who mostly verified Kelly's story, but also admitted that he didn't actually see Trevor fire the gun and he only heard the shots. According to Macon County's public court records, Trevor was arrested for reckless endangerment involving a deadly weapon and obstruction, but both charges were dismissed a little over a month later on October 22nd, 2025. In the description section of his post, Trevor states that he was forced to pay a $2,500 bond on these charges, and it nearly cost him his career and severely disrupted his household finances. And it took him 2.5 months to get his firearm back. He goes on to state that because the deputies on the scene refused to take temporary custody of the keys to his family's only vehicle so that they could be given to his wife, his family was left stranded until he got out of jail. Trevor also said that when he decided to stand his ground, he was expecting the fallout to cost him somewhere between $250 and $500. But because his arrest financially punished his family more than it actually did him, he said he wouldn't have stood up for his rights if he had to do it all over again. One thing that I think is important to touch on is that I don't think Kelly really did anything wrong here by calling the police. I do think he overstated what actually happened, and it's pretty clear to me that he didn't know what direction Trevor actually shot his firearm in. But I don't think it was unreasonable for him to assume that firing the gun was some kind of intimidation tactic from Trevor, even if it truly wasn't. I mean, put yourself in his shoes. They've had a neighborly dispute for many years. Trevor...
Yeah, here's the context, right? So he's on the property line putting up a fence that they've been disputing about, and then he hears gunshots going off real close by. And so it sounds like he's trying to intimidate him, like, hey, if you put up that fence, I'm going to shoot you, right? And so that's the neighbor's point of view. So to me, that's enough to have a reasonable suspicion based upon that context.
Allegedly watched Kelly and Julio mark off the area so he couldn't mow there anymore. Then Trevor disappears from site and they hear gunshots. I think Kelly had a right to feel unsafe at that moment, and the desire to have an official record of the incident seemed legitimate and authentic. Kelly didn't report what he saw. He reported what he believed the gunshots meant. And in long-running neighborly disputes like this, sometimes that perceived meaning can outrun the facts. Does this justify him being dodgy and somewhat mischaracterizing the facts? No. But it was obviously a real stressful situation, and I don't think it was unreasonable for him to think that Trevor was trying to scare him or intimidate him. This is where the deputies completely failed at their job. Instead of arriving on the scene and conducting an investigation into the alleged conduct, they just skipped the whole investigation and arrested Trevor for a failure to ID crime that doesn't even exist, which is why they later pivoted to the obstruction and reckless endangerment charges, even with no solid evidence that his gunfire actually endangered anyone, and no meaningful evidence that he obstructed anything beyond refusing to give his identity. If the deputies had just dropped the ID dispute and focused on the substance of the call, then this may have had a totally different outcome. Like, why not ask to see the area where Trevor supposedly fired the rounds into the ground? Or ask to see where his chickens are? And just assess whether anyone was actually endangered at any point. Why not investigate the actual alleged conduct instead of getting so hung up on trying to figure out who Trevor is? Literally every officer on the scene, including the highest law enforcement official in the county, were all enforcing a law that wasn't real. And you'd think that understanding your state's ID laws would be like the bare minimum for doing policing. But here we have a county sheriff.
This is why the idea of first principles is so important, right? Whenever you arrive on the scene as a police officer, you don't take what you hear to be true. You do your own investigation. You work off of first principles, meaning break the situation down. First of all, was a crime committed here? What facts do we have? What reasonable suspicion do we have that a crime was committed, will be committed, or is being committed? And if there's no evidence on scene, okay, if all we have is other police officers saying that someone else said something, then that's all hearsay. And that's all someone saying something, but none of that that's all circumstantial evidence. None of that is direct evidence. So if there's no direct evidence of a crime, then there's no reasonable, articulable suspicion of a crime. So direct evidence versus circumstantial evidence is a big one.
Who doesn't even know. Like I said before, I think this interaction shows how broken the state of law enforcement training really is in this country. From my perspective, what happened on the scene that day is pretty clear. The officers treated their lack of evidence and uncertainty as a justification for an unlawful arrest. They didn't have any evidence that Trevor fired his weapon in a dangerous or reckless way. All they had were ambiguous witness statements that were clearly informed by an ongoing neighborly dispute. And they used that ambiguity to demand Trevor's cooperation with a law that doesn't even exist. Look, the Constitution requires specific articulable facts to effectuate a seizure. We don't know what happened is not a specific fact. That is the absence of fact.
A specific fact, the same as the Texas case we just talked about, where Terry v. Ohio, and then what was it? Texas v. Texas. But just like the Texas case where the guy was in the alleyway, and he was arrested for failure to ID. Right, there was no primary cause for the arrest other than the failure to ID. He was in a high crime area. It was 4 o'clock in the morning. And so due to the time of day and the geographic location, that was the only evidence they had. But there was no direct evidence of a specific crime, right? So those two things, it could mean he's criminal because he's in a criminal place at a criminal time of day, but being criminal is not a specific crime. Or the suspicion of being a criminal is not the same as suspicion of a specific crime. The word specific there is key.
Fact. And police officers don't get to fill that absence with unlawful demands and unlawful arrests. And when multiple supervisors on scene all operate under the same incorrect assumptions about the law, that's not some rogue mistake. It's very obviously a training failure. Understanding when you can compel identification is not an advanced.
All right, so when can you actually stop, right? When can you ID and when can you detain someone lawfully? So if an officer approaches you on the street to ask questions but lacks reasonable suspicion that you're involved in a criminal activity, the interaction is legally voluntary. You're not required to provide ID, answer questions, or stay in the area. Now, if it's a lawful detention, a Terry stop, it's when the stop is based on a reasonable, articulable suspicion that you have committed, are committing, or are about to commit a crime. The obligation to identify yourself hinges on state law. Stop and identify states. Nearly half of U.S. states have statutes that compel you to provide your identifying information, typically your true name and sometimes your address, during a lawful investigative detention. The Supreme Court upheld the constitutionality of these statutes, so non-disclosure states, in states without these specific statutes, you generally cannot be arrested solely for refusing to ID. So, however, officers can lawfully prolong the detention while they investigate the initial suspicion. So, even if you're in a stop and ID state, like Florida is, where I'm at right now, even if you're in a stop and ID state, they still have to have a reasonable, articulable suspicion that you've committed a crime. In this video, I think they did have a reasonable, articulable suspicion. I mean, they had a report that shots were fired in the air. They had a gun. They had a magazine. They had a guy with alcohol in his breath. They had the fact that there was already a property dispute, that he was on the property line putting up a fence, which then could have instigated the neighbor to then try to intimidate him off the line, right? So they had the situational, circumstantial evidence there. I mean, there's a lot going on there. So I think they did, but I think they ruled the other way though.
Legal concept or some obscure case law. It's fundamental, basic Fourth Amendment training that every officer should know. If you are entrusted with the authority to detain without the appraisal,
All right, guys, that's it. Thank you so much. See you later. Check out my other videos on First Amendment audits and traffic stops and legal detentions. Have a good one. Peace.